Good afternoon, students. Today is Friday, 28 January 2022. This is our second lecture of the week. Typically, I would put it up on Thursday, which was yesterday, but I told you that I would get it up today, Friday instead. Next week, we will continue our discussion of the hypothetical legal case of the Spelunkian explorers. And we'll devote both days next week to this article, this famous case. Okay, at the beginning of my lecture notes, you'll notice that I have a fairly lengthy quotation from a philosopher named Peter Suber, and he tells you a little bit about Fuller, the author of this famous article. So I'll just let you read that on your own. He was, in case you're interested, he was a Texan, educated at Stanford University in California, and taught for many years at Harvard University in Massachusetts. He wrote many books and articles, and some of them are quite famous, including this one. I propose to devote 3 days to this case. Today, we will discuss the facts of the case, which, as you know, are important. Remember, when we discussed Oren Kerr's essay, he stressed the importance of understanding the facts. We'll also look at the first of 5 opinions, the one by Chief Justice Truepenny. So that's our task for today. It'll probably take only an hour, we'll see. And then next week, we'll have 4 more opinions to discuss. The first day next week, we'll discuss the opinions by Foster and Tadding. And on the second day, we'll discuss the opinions by Keene and Handy. And that'll wrap things up. So 3 days in total on this article. Now, I posted on Canvas a timeline prepared by Professor Suber. Now, this is a hypothetical case, so you can't go outside of it to get any facts. It's made up. Lon Fuller, a law professor, made this case up to illustrate certain theories of law or adjudication. So all of the facts must be incorporated somewhere in the article. And what Peter Suber has done is he's read the article very carefully, and he's put together all of the facts in the proper order. And I posted that for you on Canvas. It was somewhere on the internet, and I found it, and I thought it would be a useful supplement for you as you read through the case. So rather than going over that handout by Peter Suber, I'm going to just sketch what I take to be the main facts of the case. All right, I'm looking at page 2 of my lecture notes near the top, at the top. So the situation is this. 5 men went spelunking. Well, maybe you've never heard that word before, maybe you have. Spelunkers are cave explorers. So 5 men went into a cave to explore it. We don't know what their other purposes were. They were members of a cave exploring society. You could think of it as one of their hobbies. And I'm sure they realized that it's a dangerous activity. And you'll see why when we get further in the facts. While they were in the cave, a landslide closed off the entrance, trapping them inside the cave. Now, 20 days went by before they gained radio communication with the outside world. They happened to have a radio transmitter with them, and presumably, as soon as the landslide occurred, they tried using it. But for some reason, they were unable to get any contact with anyone outside the cave for 20 days. And naturally, they would be very excited about that because now they think they have a chance to be rescued. In their discussion with the authorities outside the cave, they learned a few things of importance to them. Number 1, they were told that it would be at least 10 days before they were freed from the cave. Now that would make a 30-day stay in the cave. That's a long time, a whole month. So authorities are already busily at work trying to dig them out. There are medical professionals outside the cave talking to them on the radio. So they can ask those medical authorities, is there any chance that we will survive 10 more days? We're already weak. from hunger. I assume they must have had a water supply. They either took water in that was sufficient to provide for them, or perhaps there was a source of water in the cave, a running stream or something. At any rate, they were told that it would be at least 10 days before they were freed. Secondly, they were told that it was unlikely that any of them would survive that long. So that's the good news and the bad news. The good news, 10 more days. The bad news, nobody's going to make it 10 more days. They were also told that they would survive if they killed and ate one of their number, one of the 5 of them. Now, maybe that person wouldn't need to be killed. They didn't say that. But what if one of the 5 died of natural causes? What they were told was if they then consumed the flesh of that deceased person, they would have a chance of reaching the 10-day period and being rescued. They then asked the authorities by radio, what do you recommend? What do you advise us to do? And apparently nobody would advise them what to do. And you can see why. The authorities on the outside would possibly be legally liable for what occurred. And they did not want to get involved in that way. So they either told them, you're on your own, you'll have to decide that for yourselves, or perhaps they said nothing at all when asked. So keep that in mind as we go through. They're having to make a decision on their own without any guidance or any instruction from the outside. Okay, on day 23, one of the 5, a man named Roger Wetmore, proposed a plan to choose someone to be killed and eaten. And ironically, the plan involved rolling dice. One of the 5 happened to have some dice in his pocket. And the idea was that the 5 men would roll the dice and someone would be chosen on that basis and would be killed, and the others would eat the flesh of the body to help them survive until rescued. So Wetmore proposed the plan. Ironically, when the plan was executed, he was the one who got the short end of the stick, so to speak. The person who proposed the plan ended up being selected as the one to be killed. Now, he refused to throw the dice for himself, even though he had proposed the idea. Someone had to throw the dice for him, and before they did so, they asked him, do you have any objection to my throwing the dice for you? Do you have any objection to the fairness of it? And he said no. So he just didn't want to do it himself. So he said he had no objection to the fairness of the throw, and he was chosen to be the one to be killed. He was killed. His body was eaten by the 4 others, and they were eventually rescued. So we can assume that the authorities told them the truth. Unless one of them were killed and eaten, nobody would survive. Now, we don't know that because they did kill and eat somebody within the 10-day period. It's possible that even if they hadn't killed and eaten anyone, one or more of them may have made it another 10 days. So that's just one of the unanswered questions. On day 32, the other 4 spelunkers were rescued. After they were allowed a period of time to recover, they were indicted for murder. There was a statute in this hypothetical jurisdiction, which is called Newgarth, by the way, Newgarth. A statute was used to prosecute them for murder. Now, we don't know what their defense was. They may have argued that that they were acting under necessity or under duress, that they were compelled to do what they did, and therefore they were not prosecutable under the murder statute. In effect, they're saying we weren't murderers. We were compelled to act as we did. And that's a common defense to a criminal charge. It's called the necessity defense, or the duress defense. I acted under duress, therefore I cannot be held responsible for my actions. Also, there's a defense known as self-defense. Someone may have argued that he was defending his own life by killing and eating someone. Now, that may be a stretch, but it could have been argued in court. There was, after the indictment, a 3-month trial. Now, that's a long time, but of course there were 4 defendants, so each one had to be charged and evidence had to be introduced that that person had participated in the scheme and participated in the killing and consumed the body. Well, they were all convicted. All 4 of them were convicted of murder, and the judge sentenced them to hang. The punishment in Newgarth for murder was death by hanging. The judge had no discretion in Newgarth. Right? If you were anyone convicted under the murder statute must be put to death by hanging specifically. Now, the jury, which heard the case and rendered the verdict, the jury, joined by the judge, made an interesting and peculiar request of the chief executive of Newgarth. You can think of it as the governor of the state if you want, but we'll call him the chief executive. The request was that the governor commute the sentences to 6 months in prison. So let me pause for a moment. As you can see in my notes, I have a paragraph in which I explain the difference between pardoning someone and commuting a sentence. Both of them are forms of clemency. Clemency means kindness or mercy or leniency. So one way for someone, such as a chief executive, to show clemency or to exercise clemency is to pardon the person who's been convicted. And that means that the guilt, the conviction, is erased from the record. You are pardoned. You're absolved of guilt after the fact. And chief executives do have that power. The President of the United States has the power to pardon, and so does the governor of each state. Those are the chief executives of those jurisdictions. Now, commutation is different. When you don't commute people, you pardon people. What you do when you commute is you shorten a sentence. So what the jury and the judge requested of the chief executive of Newgarth was shorten the sentence from death to a certain term of imprisonment. And they specifically asked for 6 months in prison. Now, strictly speaking, you're not shortening the sentence there. You're decreasing the extent of the sentence. I think everybody would rather be confined to prison for 6 months than put to death. There can't possibly be someone who would not prefer that. So it's not so much shortening a term of imprisonment, it's reducing the extent of the sentence from death to 6 months in prison. Now, what if someone had been sentenced to life in prison? What if that had been the sentence? That sentence could be commuted to 10 years in prison. So notice it's shortening it from spending your whole life in prison to spending just 10 years in prison. So commutation has the effect of decreasing the extent or the seriousness of the sentence. So what did the judge and jury ask for? They did not ask for a pardon. They did not ask the chief executive of Newgarth to absolve the 4 defendants of guilt. What they asked for was a shortening of the sentence or a lessening of the sentence to 6 months in prison. Okay, now I could easily ask a question or two on the exam about the difference between a pardon and a commutation. And in that paragraph, I set out the main difference and some of the implications. Okay? Now, what happened after that? Well, the chief executive said, I'm not going to make a decision on the request to commute the sentence until we hear from the Supreme Court of Newgarth. The case had been appealed by the 4 defendants. We don't know what the basis for the appeal was, but they appealed. They must have claimed that an error of law was made by the trial judge, and they are asking that the Supreme Court of Newgarth reverse the convictions and let them go. And if that were to occur, then the chief executive wouldn't have anything to do. The chief executive would not have to commute the sentences. Okay? So the chief executive doesn't want to have to make that decision unless it's necessary. And just to show you where we're going, it is going to turn out to be necessary. The Supreme Court of Newgarth ended up in a 2-2 tie, with one of the justices withdrawing from the case. And that meant that the original convictions and sentence were to stand. And that meant that unless the chief executive stepped in and commuted their sentences or pardoned them, they would be hanged. The original sentence of death would be carried out or executed. Okay, so those are the basic facts. Now, if you want to look at a little bit more detail, go to the timeline prepared by Professor Suber. It's posted on Canvas. So let's continue now. What was the disposition of the case? I told you a moment ago that there was no majority. It's a 5-member Supreme Court, and so it would take 3 of them agreeing for them to constitute a majority. And presumably one of them would be asked to write the majority opinion in that case. But because it ended up 2-2 with 1 withdrawal, there was no majority. There was no majority of justices. And so there was no majority opinion in the case. And since there was no majority opinion, there were no dissents from it. You dissent from the majority. If there's no majority, then there's nothing to dissent from. So none of the 5 opinions in this case could be called a majority opinion or a dissenting opinion. Okay, now look at page 3. I'm moving along in my notes. Since there was no majority or dissenting opinion, there was no concurring opinion. Nobody concurred with anyone else. Okay? You concur when you agree with the conclusion of the majority and write your own separate opinion. Or sometimes you don't have to write your own opinion. You can just throw in your 2 cents worth and say, I concur with the majority. But there was no majority in this case, so there's no concurrence. There was no dissent in this case, so nobody could concur with any dissenter either. And since there was no majority, there was no plurality either. In order for there to be a plurality opinion, there has to be a majority opinion. So what we have in this case, very interestingly, is 5 separate opinions. No one of them was the majority opinion, a dissenting opinion, a concurring opinion, or a plurality opinion. 5 justices each wrote a separate opinion. Now I put a little diagram in my notes. You can see that on the left side it says affirm conviction. 2 of the 5 justices voted to affirm. They're Chief Justice Truepenny and Justice Keene. And we're going to look at Truepenny's reasoning in just a moment. 2 of the 5 justices voted to reverse the convictions of the 4 defendants, Justices Foster and Handy, and we're going to look at their opinions next week. So those are the 2 justices who voted to affirm the convictions and the 2 who voted to reverse. The 5th justice was Justice Tadding, and as I've said a couple of times already, he chose to withdraw from the case. And we'll see a couple of things. First of all, why did he withdraw from the case specifically? And secondly, is it permissible to do so? Is it morally legitimate to do so? Isn't withdrawing from the case, in effect, to make a decision not to save the men? Because unless there are 3 justices who vote to reverse the convictions and the sentence of death, they will be put to death, assuming the chief executive doesn't pardon them or commute their sentences. So Justice Tanning was playing with fire, wasn't he? He withdrew, as you'll see, because he was disgusted. He didn't like either outcome, either affirming or reversing. So he just wanted to wipe his hands of it and say, I don't want anything to do with this. But you can't avoid moral responsibility by just refusing to make a decision. Lives are at stake. And if he withdraws, then that opens up the possibility, or at least increases the likelihood, that these men will be put to death. So we'll take up that question later. Was it irresponsible of Justice Tanning to withdraw? Yes or no? Okay, with all of that having been said, let's turn to the first of the 5 separate opinions. This one is by the Chief Justice. It's Chief Justice Truepenny. Now you may notice in my lecture notes I put male, comma, page 642. It's not really important, but all 5 of the justices are men rather than women. And I inferred that from the pronouns that Fuller uses. If he said he or him, then I infer that the justice is a male. Now, it could matter. Someone might think that men and women, for example, have different styles of judging, that there are certain differences, not just stylistic, but substantive, in the way people think or reason or decide cases. In fact, there have been some law professors have jumped in and written opinions of their own and published them. And one of them was from a feminist point of view. So I'm not making this up, the idea that men and women might see things differently and decide differently. So it's just a kind of a fact. How important it is, I don't know, but all 5 of the justices are men. And I put the page where I inferred that, where I got the information to infer that in it. You can probably ignore the rest of what I wrote in that heading where it says institutional settlement, semicolon, proceduralism. These are really notes to myself. There are some well-known schools of thought that describe how judges decide cases or should decide cases. And these are notes to myself. Justice Truepenny is a proponent of what's often called institutional settlement. He's also a proceduralist. So you can ignore those terms. I won't test you on those, I promise. But those are why, that's what those are there for, to remind me. If I ever were to write an article about this case, I could consult my notes. Right? One thing I don't like is forgetting things. If I think of something, I like to make a note of it in case it turns out to be important later. And that's all this is. Okay, what about the facts? Now, Chief Justice Truepenny wrote the first opinion in the case, and usually the facts are stated in that first opinion. So Justice Truepenny states the facts, and that's where I got the facts that we went over a few minutes ago. His reasoning was actually quite short. So let's read the final 2 paragraphs of his opinion. I'm getting my copy of the article out from my notebook. And by the way, I have a nice picture of Lon Fuller. You can see there. Lon Fuller, born in 1902 and died in 1978. So he had a fairly long life, 76 years. You can see He's wearing a suit. He was a longtime law professor at Harvard. Okay, so that's Lon Fuller, the author of this famous fictional case. Here's my copy of the article. You can see, as usual, it's all marked up, highlighted, different colors of ink, things underlined, notes in the margin, and so on. Let me try to find a page where I've got a lot of things. Got a lot going on these 2 pages. See the highlighting, lots of things written in the margin, arrows, underlining. When I read with a pen in my hand, and I read actively, not passively. I'm engaged. I have no distractions. I don't have music playing. I don't have a TV on. I find a place where it's quiet and where I can devote myself, where I can think in a very intense way. And I read very slowly and carefully, especially when I'm reading something philosophical. And as I write, I make notes to myself in the margin. If I disagree with something, I may put a note in the margin indicating my disagreement. I may find some inconsistency in the article, and I may put a note, see page, some earlier page, where there appears to be a contradiction. So that's the way you should read philosophical essays as well. Now, back to my point. Look at page 619. Let me go back. This is the 4th page of the article. And my note is read the final 2 paragraphs aloud. Okay, so here we go. These are the final 2 paragraphs of Justice Truepenny's opinion. He says, "It seems to me that in dealing with this extraordinary case, the jury and the trial judge followed a course that was not only fair and wise, but the only course that was open to them under the law. The language of our statute is well known, and here it is. This is a quotation of the actual murder statute. Quote, 'Whoever shall willfully take the life of another shall be punished by death.'" He then has a citation. Let me explain what that is. It's NCSA, and then in parentheses, NS, followed by a little squiggly line, a funny looking symbol. Think of it as 2 S's on top of each other, linked together like a chain. And then it says 12-A. Well, here's what that means. This is lawyerese. NCSA stands for Newgarth Consolidated Statutes Annotated. So it's a collection of books published by the government of Newgarth. It's a collection specifically of the statutes that were enacted by the legislature and signed into the law by the executive, the governor, let's say. Okay, so it's consolidated statutes. Consolidated just means collected and put together in one place. And the word annotated means that the person who prepared the volumes added some supplementary material, maybe footnotes, to explain when this statute was enacted and other details about it. So it's an annotated collection of statutes in the jurisdiction of Newgarth. And the letters NS means new series. So presumably there was a series of books, maybe 100 volumes. And when they got to volume 100, they started a new series, series 2, volume 1, 2, 3, 4, and so on. And maybe eventually, maybe when they get to another 100 volumes, they'll have series 3 and so forth. The little special symbol there means section, and this is section 12A of the statutes of Newgarth. Okay, so I just want to explain what that is. I'm sure that would be confusing to you, or at least strange to you. Now, let's go back and read what Justice Truepenny says. He says, "This statute permits of no exception applicable to this case." It doesn't say, for example, this is murder and here's an exception to it. There are no exceptions written. or stated explicitly. He says, once again, this statute permits of no exception applicable to this case. However, our sympathies may incline us to make allowance for the tragic situation in which these men found themselves. So, our sympathies may be with the defendants. We may sympathize with their plight. They've been sentenced to death. But unfortunately, the statute doesn't allow us to make any exceptions. It contains no exceptions. Now, what does Justice Truepenny do about that? He seems troubled by that. He's uncomfortable. Here's what he says. In a case like this, the principle of executive clemency seems admirably suited to mitigate the rigors of the law. And I propose to my colleagues that we follow the example of the jury and the trial judge by joining in the communications they have addressed to the chief executive. There is every reason to believe that these requests for clemency will be heeded, coming as they do from those who have studied the case and had an opportunity to become thoroughly acquainted with all its circumstances. It is highly improbable that the chief executive would deny these requests unless he himself were to hold hearings at least as extensive as those involved in the trial below, which lasted for 3 months. The holding of such hearings, which would virtually amount to a retrial of the case, would scarcely be compatible with the function of the executive as it is usually conceived. I think we may therefore assume that some form of clemency will be extended to these defendants. If this is done, then justice will be accomplished without impairing either the letter or spirit of our statutes, and without offering any encouragement for the disregard of law. And that's it. That's all Justice Truepenny has to say, because if you turn the page, you'll see that Justice Foster's opinion begins immediately. So we need to reconstruct Justice Truepenny's reasoning. How does he arrive at the conclusion that the convictions of these 4 men must stand? Well, if you turn to my page 4, this is my attempt to extract the reasoning or the reasoning process of Justice Truepenny. He himself did not lay it out step by step, but he could have, and he probably should have. And since he didn't, I will. Now, I may get this wrong. It's possible when you try to figure out what someone's argument is that you misunderstand it or end up misstating it. But I've been at this a long time. I'm both a lawyer and a philosopher, and this, I think, is his reasoning. Right? I could be wrong, but I'm pretty confident that if he were a real person and I were to run this by him, he would say, yeah, that's pretty much it. You've nailed it. Okay, it starts off with a certain premise. And here it is. I number it lowercase Roman numeral 1. This is the middle of my page 4 of my notes. Justice Truepenny starts off by stating this principle of interpretation. A statute must be applied as written unless A or B, unless one of 2 situations obtains. The first is that it conflicts with another statute. The second is that it's unclear in some way. So the idea is this. If the statute in question does not conflict with any other statute, in other words, there's just one applicable statute on this matter at hand, and the statute itself is clear, then it should be applied as it's written. We don't go beyond it and look at the purpose of the statute. You're going to see later that that's what Justice Foster wants to do. But Justice Truepenny does not take that approach. He wants to apply the statute as it is written, the literal wording on the page. No resort to the meaning, no resort to the purposes of the statute or why it was enacted into law. Not for Justice Truepenny. That's irrelevant. Okay, premise number 2. I just want to make explicit that this is a statute. This NCSA section 12A is a statute. It's not a judicial precedent or a constitutional provision or anything else. So when you put 1 and 2 together, premise 1, which is a principle of interpretation, and premise 2, which simply tells you what section 12a is, you get the following. Roman numeral 3, NCSA 12a must be applied as written unless either it conflicts with another statute or it's unclear. Do you see why 3 follows from 1 and 2? It's a simple, straightforward inference. You may think we haven't made any progress, but we really have, because premise 1 was a general principle of interpretation. It made no reference to section 12a or any other statute. But when you put 1 together with 2, you do get 3, which follows from those premises. But the argument's not done yet, because Justice Truepenny, Chief Justice Truepenny, has to claim that neither of the 2 exceptions applies. Remember the 2 exceptions? The statute must not conflict with another statute, and secondly, the statute must not be unclear. So premise 4 makes that explicit. Let's read it. NCSA 12a does not conflict with another statute, and it's not unclear. Not unclear means it's clear, right? The language is clear. Okay? Whoever willfully, I don't have it in front of me, whoever shall willfully take the life of another shall be punished by death. That's the statute. It looks straightforward, it's clear, and according to Justice Truepenny, there's no other statute in Newgarth that conflicts with it. If there had been, then the defendants would have raised it during their trial, and presumably they did not. Now, what do you get when you put Proposition 3 together with 4? Remember, 3 was the first conclusion. It came from 1 and 2. We then added a new premise, 4, and together with 3, we get a new conclusion, 5. 5 says, therefore, NCSA 12a must be applied as written. You see why that follows from 3 and 4? So at this point, Justice Truepenny has arrived at this intermediate conclusion. We have to apply the statute as it is written, because neither of the 2 exceptions applies. All right, turn to page 5 of my lecture notes. The next premise is 6, premise 6, or proposition 6. NCSA 12a provides that, quote, whoever shall willfully take the life of another shall be punished by, shall be punished by death. That's simply the language of the statute. New premise, 7, the defendants willfully took the life of another. That's the finding of the jury at the trial. The jury and the trial judge, came to the conclusion that they did willfully take the life of another. That would have been Wetmore, Roger Wetmore. And what do you get when you put 5, 6, and 7 together? What follows logically from those 3 propositions? You get the conclusion that defendants shall be punished by death. Okay, that's the grand conclusion. And that's the decision that Chief Justice Truepenny made. So what is he doing? He's applying the language of the statute as it's written, which is clear and which doesn't conflict with any other statute. He's simply applying it to the facts of the case, and he's reaching a conclusion. That doesn't mean he likes the conclusion necessarily. He may or may not. He's acting as a judge. He's trying to fulfill his responsibilities as a judge. The role of a judge is not to make law, at least in his view. The role of a judge is not to make law. The law was made by the legislature of Newgarth. That's section 12a. The judge's job is to apply that law to the facts as discovered by the jury at the trial and reach a conclusion. And Justice Truepenny says for better or worse, whether I like it or not, the defendants are guilty of murder. And they were duly sentenced by the judge. Remember, the trial judge had no sentencing discretion. If you're found to be guilty of murder, you must be sentenced to death. And that is carried out by hanging. So if you disagree with Chief Justice Truepenny's grand conclusion, you have to find fault with this reasoning, if indeed this is his reasoning, and I think it is. You're going to have to show that one or more of his premises is false, or you're going to have to show that one or more of his inferences is invalid. Now, the inferences that I reconstructed for this argument appear to be valid. So really, the only thing you could do if you disagree with Chief Justice Truepenny's conclusion is find a premise to challenge or to reject. And the main one that I see is premise one. Remember, premise one is I keep saying justice, he's the Chief Justice. Premise one is Chief Justice Truepenny's main premise. It states a principle of interpretation. There are other possible principles of interpretation than this one. So you'll see that when we look at the reasoning of other justices, some of the other four justices, some of them disagree with Chief Justice Truepenny. They would start off with a different principle of interpretation other than this one. So what we have here is Chief Justice Truepenny starts off with his own preferred principle of interpretation, and it leads him to the conclusion that the sentences of death are to be affirmed. If you start off with a different principle of interpretation, you may not get to that same grand conclusion. You may end up, in fact, with a reversal of the sentences, the conviction and sentence. So for Justice Truepenny, this is an easy case. I'm going back now to page 3. For Justice Truepenny, this is an easy case, legally speaking. I don't mean it's emotionally easy, because it's not. It's emotionally difficult, because according to Chief Justice Truepenny, these defendants were properly convicted and sentenced to death. And that probably troubles him. So emotionally, this is a difficult case. But legally speaking, it's open and shut. It's an easy case. You've got a single statute. It doesn't conflict with any other statutes in the jurisdiction. It's clear on its face. It clearly applies to the facts of this situation. And therefore, the conclusion is that the sentence and the conviction and sentences of these four defendants were proper. Now, Justice Truepenny, just to show you that he's troubled by this outcome, advocates that his fellow justices join him in communicating with the chief executive of Newgarth and throwing in their 2 cents worth and saying, look, you have the power of clemency. We don't, right? We're judges. You are the elected chief executive. And the Constitution of Newgarth presumably gives you the power to pardon people and to commute sentences. So we, having heard this case on appeal, we who are familiar with the facts, we recommend that you use your executive power to commute the sentences to, say, 6 months in prison. Now, probably they've already served at least 6 months in prison, because it takes a while for the appeal to be to be completed. So if the chief executive commutes the sentences to 6 months in prison, they'll be freed immediately because they've already served their time. So that's Justice Truepenny's solution. Now let me ask you, is this appropriate? Justice Truepenny probably went to sleep that night with a clear conscience. He believes that he carried out the law as written. He believes that that's his job as a judge. And if that gives him any moral qualms, because four men whom he must think are not deserving of death are going to be put, or possibly could be put to death, he may be able to sleep at night because he has written a letter to the chief executive advising commutation of the sentences. So, in a way, he's trying to have it both ways, isn't he? He wants to be faithful to the law as written and do what he thinks a judge should do, which is enforce the law, not write the law, not make the law, but enforce the law, apply the law. So he's doing his duty as a judge, and because he has moral qualms about these men being put to death, he feels that by writing a letter to the chief executive recommending commutation of the sentences, he has done his moral duty as well. And that would allow him to sleep at night. But I ask you, does he really have reason to sleep at night? First of all, the chief executive may well ignore his advice, the advice of the jury, the trial judge, and any members of the Supreme Court who advise commutation. And was it not within Chief Justice Truepenny's power to reach a different result? He arguably could have reached a different conclusion. After all, two of his colleagues did so. All right? Justices Foster and Handy voted to reverse the convictions. Chief Justice Truepenny could have joined on to their decisions. He did not. He voted to affirm the convictions and the death sentence. So he's playing with fire, isn't he? He is taking a chance that the chief executive will not commute the sentences and that these four defendants will be put to death. In other words, you could say that Chief Justice Truepenny is passing the buck. He had it within his power to see to it that these men were not put to death. He passed the buck to the chief executive, leaving the decision to the chief executive. Do you know what that term, buck passing, means? That means passing on responsibility to someone else. The story is that President Harry Truman had a sign on his desk that said, "The buck stops here." So he was familiar with that phrase, passing the buck, letting someone else make the decision. And Harry Truman was saying, I don't do that here. I'm the president of the United States. The buck stops here. I don't pass the buck to anyone else and let them take the responsibility. I'm responsible. I make the decisions. And in his view, that was the way it was supposed to be. The president should make the tough decisions, not pass the buck. So what I'm suggesting is that Chief Justice Truepenny may be avoiding responsibility for the deaths of these men by passing the buck to the chief executive. Okay, one more point. If you look at my page 3, I have a note that says, what does the word willfully mean? Willfully. Because that's one of the words that's in the statute. A case could arguably be made that these defendants did not willfully take the life of anyone, including Roger Wetmore. And the argument would be that it was not a matter of will. They didn't will his death. They were compelled to do what they did. They were so hungry, so desperate, that they really didn't decide anything. They didn't act in accordance with their own wills. They were compelled to do as they did. And the argument would then be that the statute does not apply to them because it was not a willful act. Now, that argument is probably going to fail uh, because there are no explicit exceptions to the statute. It doesn't say, for example, that this statute does not apply in cases of necessity or duress or self-defense. Okay? And that means that the word willfully can't be read in the way I was suggesting a moment ago. Right? They acted willfully. They didn't kill Wetmore by accident. It was part of a plan. Yes, they were desperately hungry, and yes, they were at wit's end, but the killing of Wetmore was not something accidental. It was an act of will. They chose it. It was voluntary. And so the argument that the statute doesn't apply to them, I think, would be a losing argument. And we don't know whether they made that argument at the trial level or not. What I'm suggesting is that if they did, the trial judge would have ruled that it failed. The argument was not accepted. Okay, I have a handout on Canvas now. I put it up yesterday. It's entitled Hard and Easy Cases at Law. It's only one page long, and I'd like you to read it over. Chief Justice Truepenny thinks that this is an easy case. It's not a hard case. It's not difficult. We got a single, clear statute. It clearly applies to the facts of the case. You derive the result. It's just a logical exercise for him. Now, it's a hard case emotionally. Remember I said that earlier? Even Chief Justice Truepenny would say, this is heartrending, this case. But legally speaking, it's an easy case. So read over that handout. It explains the difference between a hard case and an easy case at law, legally speaking. Okay, I think I've pretty much covered what needed to be covered. If there are things in my notes that I didn't discuss today, one reason for that may be I intend to talk about it later, next week sometime. Remember that on the exam, I will hold you responsible not only for what I say in my lectures, whether they're live in the classroom or recorded, but also for my lecture notes. When I post my lecture notes, that imposes a responsibility on you. I'm sure you like having them. You would rather have my lecture notes available to you than not have them. But it also has a downside. It means that everything in my lecture notes is fair game for you and could show up on the exam. Now, I'll be reasonable, I promise. I won't try to trick you and say, well, that was in my lecture notes. You should have known it. I'll pick out things that are fairly important and that I think you could have understood even if I didn't lecture on them. Okay, so that completes our second lecture for the week, a little bit less than an hour. And we'll probably spend a little bit longer on the next lecture because we're covering two opinions next week. Today, all we did was the facts and one opinion. Next week, we have the opinion by Justice Foster and the opinion by Justice Keene. And the opinion by Foster and Tatting on the first lecture next week. And the opinion by Justice Foster goes on for quite some time. In fact, he makes two different arguments, so that'll take a little bit longer. In the meantime, have a great day and a great weekend. Make sure you keep checking Canvas. When I post something, you need to print it immediately, read it, put it in your notebook, and bring it to class, or in the case of a recorded lecture, have it available when you watch my lecture. Okay, so everything should be available to you when you're listening to me, so you can consult it. And you can also stop the video and find something that I referred to in my video, in my lecture, and read it before you click resume. Okay, enough for today. Again, have a nice weekend, and I'll see you on the screen next week, probably Tuesday and Thursday. But I'll let you know if the lectures are going to be put up a day late.